Good evening, you're watching News Today at 9 p.m. I'm Preeti Choudhry. Our big talking points over the course of the next 1 hour. Well, the Supreme Court waded in where the Waqf law was concerned. Waqf status quo now till the 5th of May. With that, we have an exclusive lined up for you. One of the petitioners was Asaduddin Owaisi of the AIMIM. He's going to be joining us live. Also, how will AI impact political campaigns? Something strange is happening in the state of Maharashtra, and we'll tell you exactly what. All of that coming up over the course of the next 1 hour. Big development came in from the top court today. The apex court has refused to stay the controversial Waqf Amendment Act 2025, delivering what many see as an interim setback for the centre. While the law remains in force, the court has ordered strict status quo injunction on some of the contentious provisions of the Waqf bill or the Waqf law. Now, these two come in especially where Waqf properties are concerned, categorized as Waqf by user, halting any change until further hearing. More so also on the inclusion of non-Muslims on the board. Here's more. Top court steps in on Waqf law. Interim setback for government. Injunction on Waqf's contentious provisions in new law.
The Supreme Court has said that the Central Waqf Council and the State Waqf Board will not be constituted. Waqf by user cannot be deleted. Now, there are other provisions also which we as a party have come to the Honorable Supreme Court that calling it unconstitutional.
This is not reform. It is retaliation in the guise of reform. It is retaliation meticulously scripted, strategically timed, and constitutionally questionable. The Waqf Amendment Act is not an exercise in efficiency as it pretends to be.
While the Supreme Court refused to grant an interim stay on the Waqf Amendment Act 2025, the status quo on certain contentious provisions of the new law are being seen as a setback to the government. Interim setback 1. The top court directed that there would be no alteration in the character of any Waqf property, including those registered as declared under the practice of Waqf by user. Waqf by user is land used by Muslim religious or charitable purpose for a long period of time. It is deemed to be Waqf property even if it was not registered as one. Nearly half of the 8 lakh odd Waqf properties in India are Waqf by user. The Supreme Court noted such properties would not be denotified as Waqf by user for now, which was proposed by the new Waqf Amendment Law. The court ordered that all Waqf properties, regardless of how they were classified, must be preserved in their current state until the next hearing. There were concerns expressed by the top court over the Waqf by user provision in the new law, which said if the district collector identified any Waqf by user property as government land, it would cease or be denotified as Waqf property till a court determined its status. The Supreme Court was of the view that a court should decide that and that Waqf by user denotification should not happen before that. Interim setback 2. The top court told the government that non-Muslims won't be appointed to central Waqf councils and the state Waqf boards. The Supreme Court made the union government assure that no appointment of non-Muslims to the Waqf Council and board would be made till the next date, which is 5th May. It also directed that no new appointments be made to any Waqf board during this period. The centre assured the Supreme Court that no Waqf properties will be denotified till the next date of hearing on 5th May 2025. This means that disputed Waqf land cannot be touched. This means the government cannot take land claimed by Waqf. It also means that even disputed land cannot be taken by the government. The petitioners, many of which are opposition parties, are claiming interim victory, while the government now has 7 days to file a preliminary response with relevant documents. Bureau Report, India Today. All right, let's get in Asaduddin Owaisi, AIMIM chief. He's also a petitioner in his party where the Waqf law is concerned. Appreciate you taking the time off and joining us, Mr. Owaisi. My first question. Now, there has been an injunction, at least, on some of the most contentious provisions of the law. Do you see now, at least the Supreme Court has seen merit in what petitioners like you have appealed for?
Well, the Honorable Supreme Court have given an interim relief on the lines of not to constitute the Central Waqf Council and the State Waqf Board, and that all Waqf properties which are registered, notified, and also Waqf by user will not be deleted. Now, this is subject to the final order that is uploaded, or I'm yet to see, but this is what I had understood. But I would be very cautious in saying this, that our legal battle against this black and unconstitutional act continues. And we have consistently opposed all these amendments in the Joint Working Committee of the Parliament Committee and in the Parliament when the Parliament took the deliberation voting on this bill. So the legal battle continues. There are many provisions, many amended sections in this act which are very dangerous and which will weaken and destroy the Waqf board. So that is why it's an interim relief, and we have to continue with our legal battle, continue with our public protest against this black and unconstitutional law, which violates freedom of religion, it violates fundamental rights, and that is why I feel that the legal battle and the public protest will continue.
But Mr. Owaisi, what you call as an interim relief for you is also being read as a possible interim setback for the government. But the top court did not stay the law with what you had appealed for. You wanted the law to be struck down. The top court has seen merit in some of the provisions of the law. From here on, do you at least admit now that your legal fight and other petitioners' legal fight will have to be limited to the provisions of the law now, not the law itself?
We don't know. The Supreme Court has given dates now. We don't know what will happen on those dates, but we'll have to wait and see. But the legal battle against this act on behalf of the petitioners, on behalf of All India Muslim Personal Law Board, will continue. There are, for just now, as I've told you, that there are many provisions. For example, this section which says that you cannot give a property to a Waqf unless and until you're a practicing Muslim for 5 years. Now, look at the stupidity of this amendment. Who will classify or give a judgment that I'm a practicing Muslim, especially if one happens to be a woman? Secondly, the application of Limitation Act from today, Waqf Board would be losing numerous number of Waqf properties because the encroachers will become owners now. And the most unfortunate part is that the section 2, wherein the trust will not be Waqf anymore. So this directly benefits from today the richest man in India who had built his palatial house on a Khoja orphanage. He will become the owner now. We will be losing the Waqf evacuee properties, especially in Punjab and Haryana, which are source of great revenue to those Waqf boards. They will be under government control, government custodian. The Waqf board will not be the owner. The government of India, central government, will be making rules which will be violative of federalism. The collector can still issue an order to a mutawalli telling him to do something un-Islamic or something stupid, which will again, if he doesn't accept, he can be sentenced for 6 months. There are many provisions, in this bill, and then the time is ticking to register all Waqf properties on the portal. If you don't register in 6 months, then it will not be Waqf. So there are many sections in this law of amended law of Waqf, which are very grievous and harmful, not only to the constitution of our country, but also to the Waqf board itself, Waqf properties itself.
So there's an understanding right now, Mr. Owaisi, by the petitioners that they'll have to go provision by provision because of all the contentious, the other provisions that you have just, recalled, to is in what the top court or the Supreme Court has seen merit in and has, you can say a stay or there's an injunction on those two provisions. But the fight will now from here on legally will be provision by provision because the government's clear. They see merit in the act. They also say very clearly that some of the provisions are for the better.
Well, when the final, arguments will start from the 5 petitioners who are against this law, then everything would be argued in detail in front of the Honorable Supreme Court when the Supreme Court decides to hear and lays down a timetable or whatever it is. But as far as the All India Muslim Personal Law Board is concerned and the Muslim community at large is concerned, they have rejected this law. We have called it an attack on our religion. We have called it an attack on the Constitution. It's a direct attack on the fundamental rights, Article 14, 15, 25, and 26. And we feel that we are of the strong opinion that this law is not brought in to save Waqf properties or to increase their revenue or to get rid of encroachers, but it is brought in to do the opposite, to weaken all the Waqf properties.
Mr. Owaisi, you've debated on it in Parliament as well, and this one point was very contentious in Parliament where the centre raised it up. The centre also raised this in court, where, they say the lack of representations, especially about entire villages being claimed as Waqf property to justify these amendments. That is what the centre claims. What is your response now to the concerns of what is deemed by many as widespread and the question over the legitimacy of the Waqf law?
Now, look at the hypocrisy of the government. You say in one breath that we want to save Waqf properties, we want to increase the revenue. And what you're doing right now, you're rewarding the encroachers. By applying the Limitation Act, you are rewarding the encroachers by making them the owners of the Waqf property. Secondly, about this wrong example of villages being classified as Waqf. I happen to be a member of that joint working committee, and wherein in media it was widely discussed about some village in Tamil Nadu. But when the Tamil Nadu government representative came to this joint working committee and explained to all the members of the committee, and everyone was happy and shocked to hear that how it was portrayed by BJP in the media. It is no more an issue. That issue has been solved by the Tamil Nadu government. Now, as far as the Kerala example is concerned, I want the BJP to tell those people who are now very upset that what is the history of that property? Is that property a Waqf property or not? And how will this law help them? Please tell them, explain to them. You are unnecessarily trying to create conflicts between religions. That is your whole intention. And that is why the truth has come out, and people will see that BJP is playing with their minds and unnecessarily trying to create conflicts everywhere.
Mr. Owaisi, appreciate you taking the time out and speaking with us. Thank you there. You're a petitioner in this case. You say it's interim relief, but you are also right, it is interim, only till the 5th of May when the next hearing comes in, where two contentious provisions of the Waqf law there's an injunction on that. You could say they've been stayed or their status quo till now. A relative win for the petitioners, but it's only interim. With that, I want to quickly bring in as well Anas Tanveer, advocate on record, Supreme Court. He's also fighting the case for one of the MPs who have also filed a plea with the Supreme Court to strike down what is being alleged by the MP as unconstitutional, the Waqf law. Mr. Tanveer, now what do you make of what the Supreme Court said today? Because there is no stay on the Waqf law, which is what the petitioners wanted, but the contentious provisions, clearly there's an injunction on those, two of them at least.
See, the two most important provisions that had a nationwide and a widespread implication have been effectively stayed. So as of today and until the next date of hearing, there cannot be any appointment in the Waqf board or the council and also the Waqf by user, registered and declared Waqf, the nature of the same cannot be changed. So these two had a widespread ramification, and they have been effectively stayed by this Honorable Court.
Mr. Tanveer, would you elaborate on the importance of these two provisions? Because, that could be the core also of, what many of the petitioners want. Would you elaborate on them and how they tend to benefit the petitioners?
See, if the government had the power that they have taken with this legislation to change the nature of Waqf, to abolish the Waqf by user completely, that has been stopped, because most of the Waqf, if not all, rather many of the Waqf that we have today were established long ago. There cannot be any registration because the one who gave this endowment are no more, their generations have gone, but it has been used as a Waqf property. This provision, the 3B provision, wanted a registration and a complete declaration saying that who instituted this Waqf, on which date, and so on and so forth. And obviously, the person, the Mutawalli, has to give a certain date. If he fails to give that certain date, he will be sent to prison. Now, with the stay on this provision, it is very important to understand that there cannot be a registration change of the nature of the Waqf. The power of the collector also, a lot of the power flows from this provision only. That has also been effectively stayed. And importantly, the part where the whole Waqf Council composition was being changed, the composition of Waqf Board was being changed, non-Muslims were allowed in. Matter of fact, if we count the numbers in the Waqf Council, the numbers of Muslims might be less than that of non-Muslims in a Waqf Council. So all those provisions have been stayed for now. So it is a small but important victory for us for time being.
Well, interim victory, small though, but the defense, that I asked Mr. Owaisi as well, which was also made in court, is how, entire villages are being taken in and claimed as Waqf properties.
Yes, millions of response have been sent by Muslims opposing the Waqf Amendment. One. Second, if they say that there has been deliberation in the JPC, but all the amendments proposed, all the dissent notes by the opposition members in the JPC were discarded, while all of them by the BJP members and their allies were allowed. So let them put this on record, let them bring their affidavit, we will file our reply to that. But merely saying that there has been a widespread consultation, what was the nature of the consultation? What was the record? I know for sure that millions of Muslims have sent emails opposing the Waqf Amendment. Now, will they bring that on record? Will they bring that number also on record? Because we might try to find out how many have sent. So we will have to see, we'll have to wait for the affidavit to come. Once the affidavit is before us, I will be in a better position to respond to this.
Okay, you're talking about the affidavit which the government has to file in 7 days' time with proper paperwork. Away from all of that, do you now, at least there is a realization that the law will stay, but you'll have to take the fight provision by provision?
See, let me just, for the record, the court has said that the matter will be listed in the week commencing 5th of May. Okay, not 5th of May. So a lot of people have been saying that the next date is 5th of May. That is not the case, first. Second, yes, we are quite happy. We will be pushing for more stay. We will be, we have already argued that there are other provisions also that have to be stayed. We will be pushing for that, and we are hopeful of the outcome on the next date of hearing as well.
All right. Mr. Tanveer, now your particular petition highlights issues like the precondition of 5 years of practicing Islam for creating Waqf and restrictions on Waqf. How will you argue that these provisions are arbitrary and violate Islamic law and customs? Because you will go into provision by provision.
They not just violate Islamic law. Please understand, they say practicing Islam. How do you establish if someone is a practicing Muslim or not? And why should I establish this to any government agency or to any representative of the government? It is between me and my God, and state has nothing to do with it. So this provision is constitutionally arbitrary. It creates a different class. I have also filed another petition representing the MP from the Lakshadweep. He belongs to Schedule 5 area, and there is a complete ban. The amendment puts a complete ban on creation of Waqf in the Schedule 5 area, and it's Schedule 5 area or Schedule 6 area. Now he's saying that how can you ask me to choose between my religion, my religious identity, and my tribal identity? They both are protected by the Constitution. They both are sacrosanct to me, and that is the crux of the case. The state cannot force me to prove that I'm a practicing Muslim.
Okay. One final question that I'll ask you, Mr. Tanveer. Your petition has focused, your petition in particular, on the fact that Waqf Act somewhere down the line violates Article 14, the principle of equality. Now, with what the court said yesterday and today, if we call it an interim order, do you think it's encouraging for you going forward?
Yes, it is quite encouraging, and the court's view has not been against us. It has quite been in our favor. But as I said, these are deliberations. Whatever happens in the court, unless it is recorded in the order, it remains a deliberation. A lot of time judges say things to prod the response, to get a response from the councils. So it will be wrong to say that the court has framed a positive opinion or a negative opinion. The matter is still sub judice. We are still on the stage where an interim stay will be further requested. So I don't think the court has framed. It is positive for us as of now, but the hearing is not over. It is still sub judice.
True, and you're approaching it with caution, is what you said. Appreciate you joining us. I'm also joined right now by Vikas Singh, Senior Advocate, Supreme Court, and former Additional Solicitor General of India. So my first question, stems from the fact that the top court could have continued to hear the case or transfer it to a high court, but didn't do so. They did pass an injunction. The fact that they have found merit to stay status quo or pass an injunction on two very controversial provisions of the law, do you think that somewhere down the line the court has clearly seen merit in the petitioner's case against the Waqf law?
So there are definitely issues being raised by the petitioners, which the Supreme Court feels need consideration. As of now, they have not passed any interim order. They have kept the matter for the reply of the Union of India. And it is only the Union of India is not able to give a satisfactory answer to the clauses, referred to by the petitioners, that a question of passing an interim order will arise. So far, they have actually heard only the petitioners, and they have not seen the entire act, and they have not seen the scheme of the act. Probably once they see the whole scheme, then a stay, the question of stay may not arise.
But the sheer fact, Mr. Singh, that the court today saw merit in at least passing an injunction on two of the most, contentious, controversial provisions, be it by Waqf by user or non-Muslims on boards. And, they've made that clear that the government can't act on it and there's status quo. If that continues, at least right now it's only interim till the next hearing, which is on the 5th of May. But if that continues, somewhere down the line, do you think the law will be defanged?
So according to me, there are basically 2 or 3 contentious clauses which the Supreme Court is actually examining. One is the participation of non-Muslims in the Waqf board. Now that the government has taken a stand that there will be only 2 non-Muslims apart from the ex officio members. Although there is no clarity in the act, it would have been better if it had been spelt out, in the act itself, that there will be maximum of 2 non-Muslim members in the board. But this can be read down by the Supreme Court by saying that 2 non-Muslim will be the maximum 2 non-Muslims, and it will not exceed 2 people of the not subscribing to the Islam. The other contentious clause is with regard to the survey by the officer senior in rank to the collector when the government claims it to be government land, Waqf land to be government land. The objectionable clause which the Supreme Court is finding so far is that while the survey is going on, the rights of the Waqf will be suspended. It will be not deemed to be Waqf during the period of survey, which sounds a little, odd, because whatever decision should happen after the survey is over, not at the time when the survey has just started. So that is the other clause which they are considering of, tinkering with. And lastly, the Waqf by user is something which they are worried that why this is being done away with. And in my view, that is not really a problematic clause, because Waqf by user, past Waqf by user is being acknowledged in this act, and those Waqfs will remain. It's only the new Waqfs which will be created post this act has coming into force will not be by Waqf by user, they will be only by a deed, which according to me is to the benefit of the person who's creating the Waqf, because by keeping a Waqf by user and without spelling out the terms of the Waqf, you are actually creating uncertainty for the future. So it's better to have it on a deed and get that deed registered with the board. Because really speaking, even though the Muslim law may permit Waqf by user, the Article 26 permits the state to make a law for the administration of these properties. And while administering the property, if the state feels that having a document with regard to fresh Waqf, not the earlier ones will not have to be registered. I mean, they will continue to remain if they've already been registered under the earlier act.
But Mr. Singh, the fact, on what you touched on, where you say it will not have an issue in your view, which is the Waqf by user provision. But on that argument, Abhishek Manu Singhvi in court has argued that, 4 lakh of the 8 lakh existing Waqf property, lakh hectares, are perhaps by Waqf users only, and that the newly induced provisions makes them non-existent by just one stroke of a pen.
No, that's not correct. So that's a wrong interpretation. It's a wrong argument. That's why the reading of the act will have to be seen. It only says that henceforth Waqf by user will not be done. And all Waqfs prior to this act, even by user, will be allowed to continue, and there will be no impediment in those Waqfs, and their status will not in any manner be, diluted, or there will be no takeover of these Waqfs. So there is no question. It's a complete misreading of the act. Only thing which they are ultimately wanting to argue is that Waqf by user henceforth also should be permitted. And they say, as per Islam, this is something which is permissible. But I agree that it is permissible as per Islam. But the state, when it has the right to make a law, it can always make a law for registration or for a document to be created of a Waqf by user. Like, for instance, in a family settlement, there could be an oral family settlement, but it has to be ultimately recorded in the form of a yadasht. And then only among Hindus that family settlement becomes enforceable by law. So I don't see any impediment or any real big legal lacunae in asking a Waqf by user to record record in a document the terms of the user and and how the Waqf will operate in the days to come. So I personally feel that is not something which is an objectionable clause. It is only being sort of blown out of proportion by the petitioner side.
Right. Mr. Singh, also the centre has now 7 days to file its own reply. And because, it is a politically surcharged case, we've seen that many of the petitioners are political parties. A lot of people and these political parties are calling it a setback for the centre. How would you react to that?
No, so asking to file a reply can never be considered a setback. I mean, the earlier Waqf Acts were also challenged and they were pending in the High Court. Now Supreme Court wants to examine the whole thing here. Probably will transfer the ones which are pending in the High Court also. And while examining a statute, the other side definitely has a right to file its reply. And asking for a short reply before passing an interim order is something which is quite usual. It can't be said to be a setback under any circumstances. Because filing a right to file a reply, there is a right with the court to pass an ex parte order. They could have passed an ex parte interim order also. So they have probably felt that taking a reply will be better for them to take up to understand what exactly are the provisions of the Act and how they are to be interpreted. For instance, in the reply, supposing if the central government were to say on affidavit that the board will not have more than 2 people as non-Muslims. Now, if that is recorded on the affidavit, the section can be read down on the basis of the affidavit, and that apprehension of the petitioners will automatically be satisfied. So I don't see this to be a setback at all for asking them to file a reply.
Mr. Singh, do you think it's going to be now a very long, protracted, prolonged case and battle, because the court has said it will be hearing only 5 main petitions, but given that almost all clauses, all provisions are being challenged by the petitioners, do you think a final decision is a long way away?
No, so obviously on the next date, final decision is not going to happen. So they'll be fix up a date for hearing. It may take 6 months, it may take 1 year. That will depend on the priority which the Supreme Court attaches after the interim order, whatever if it is they're proposing to pass. But if they feel that if they pass some kind of an interim order which protects both the sides, then there may not really be any urgency to hear the matter. So a lot will depend on what happens on the next date of hearing. If no interim order is granted, then I'm sure they will post the matter for hearing very soon and decide the matter also expeditiously. But if they pass some kind of a working arrangement, pass an order which can be said to be some kind of a working arrangement, then there may not be any necessity to hear the matter urgently. And then they may hear it on its turn, which may take time. So a lot will depend on what happens on the next day.
Right. Just one final question, Mr. Singh. There's a lot of outrage, or shall I say concern, being expressed by people who support the bill. They claim that this was a bill that was passed after a lot of consultation, after a lot of discussion, debate, stakeholders were involved. The supporters of the bill are asking if it would be right for the court to grant any interim stay at all. This is what a lot of people are asking who support the bill.
So, court has not granted any stay so far. Court is merely hearing the parties at the moment. So why are you, judging what the court is going to do on the next date of hearing? For all you know, if the central government is able to satisfy the court about the misgivings that have been created by the petitioners, there would be no questions of any stay in this matter. So I don't see why should we perceive this hearing as if the court has already taken a call to pass an interim order. So I don't think there is any such apprehension.
Okay. Well, thank you. Thank you for taking out the time and joining us this evening, Mr. Vikas Singh. We're going to let it be at that, viewers, because right now it's just status quo. There's no real development at that. You can call it interim relief, interim setback, but just focus on the word interim. The next hearing on the 5th of May. One thing there is clarity on. Yesterday, the top court of the country has said that we could hand over the case to the High Court. They're not going to do that because they've already started, passing observations, so they are hearing the case. It's going to be heard by the Supreme Court itself. That is at least something that we know right now. Okay, with that, I want to quickly shift focus to this intriguing story that is developing all across the world, especially in India, where the use of AI in politics is concerned. In a political first in India, the Sena Uddhav Thackeray faction has bought back the voice of Balasaheb Thackeray through artificial intelligence, AI. At a rally in Nashik, an AI-generated speech in his signature style took direct aim at Eknath Shinde and the BJP, sparking sharp reactions from the ruling Mahayuti.
जमलेल्या माझ्या तमाम हिंदू बांधवांनो, भगिनींनो आणि मातांनो, आज तुफान गर्दी दिसते.
हिंदू हृदय सम्राट शिवसेना प्रमुख माननीय श्री बाळासाहेब ठाकरे यांचा.
A speech by Balasaheb Thackeray rendered by artificial intelligence for the current times.
शिवसेनेने गेल्या 50 वर्षात किती सोसले हो.
That was the highlight at the Shiv Sena's UBT's public meet in Nashik on Wednesday.
शिवसेनेच्या विचाराने भारल्या गेल्या आहेत.
The nearly 13-minute speech with a booming voice resembling that of Shiv Sena founder.
अरे नाशिक म्हटल्यावर गर्दी उसळणारच. नाशिक आणि शिवसेनेचं एक नातं नाही म्हटलं तरी आहेच, आणि ते राहणारच. ही लोकशाही आम्ही मान्य करणारच नाही.
The AI-generated speech targeted Deputy Chief Minister Eknath Shinde.
जे नामर्द डरपोक गेले ते गेले, अहो ते गद्दार गेले ते गेले, त्यांच्या स्वाभिमानाच्या गोवऱ्या सोनापुरात गेल्या. त्यांना पैसा, अडका, मंत्रिपदाच्या वतनदाऱ्या आज मिळाल्यात हो, पण इतिहासात तुमची नोंद फितूर आणि महाराष्ट्राचे गद्दार म्हणूनच राहणार. नरेंद्र मोदी म्हणतात तसं हे नातं नाही की.
It did not spare the BJP either.
कमळाबाई म्हणजे एक ढोंग आहे, ढोंग. भारतीय जनता पक्षाला महाराष्ट्रात काय, अरे देशात कोणी ओळखत नव्हते तेव्हा आम्ही त्यांना खांदा दिला. 25 वर्षे आमचं एक नातं त्यांच्या बरोबर नक्कीच होतं. अर्थात हिंदुत्व म्हणून महाराष्ट्रात शिवसेनेमुळेच ते वाढले, बरोबर ना? काय मग नातं तोडलं कोणी?
सुनील भाऊ बाबुल.
The AI speech of Balasaheb Thackeray comes at a time when Uddhav Thackeray's rivals are using the Sena founders' old soundbites targeting Maharashtra Vikas Aghadi Alai Congress to mock the former chief minister. The ruling coalition Mahayuti, however, is not amused by the use of AI by the Sena UBT.
बाला साहब हयात नहीं होने के बाद उनको उनकी स्पीच, उनका आवाज एआई के माध्यम से बनाकर अपनी जो पूरी इज्जत चली गई है महाराष्ट्र में, वो वापस लाने का प्रयास किया है. ना पार्टी के लिए वो अच्छा है एआई के माध्यम से बाला साहब की आवाज को इस प्रकार से प्रसारित करना, ना उनके पिता पुत्र के नाम से भी व्यक्तिगत रूप से देखेंगे तो भी ठीक नहीं है.
मान्यवरांच्या खुर्चीच्या मागे
The Sena UBT defended the use of AI.
नरेंद्र मोदी जो देश के प्रधानमंत्री है वो बार बार एआई टेक्नोलॉजी के ऊपर बात करते हैं. अगर किसी ने ये टेक्नोलॉजी का इस्तेमाल किया है तो उसमें गलत क्या है? कोई गलत नहीं है. बाला साहब ठाकरे कुछ बोल रहे हैं इस टेक्नोलॉजी से आकर और सच बोल रहे हैं. आप गद्दार को गद्दार नहीं कहेंगे तो क्या कहेंगे बाला साहब ठाकरे?
अरे महाराष्ट्रात त्यांना आम्हीच वाढवलं.
This is the first time the Sena founder's AI speech was used by his son's party to target his opponents. The party could use this strategy in future rallies as Uddhav Thackeray faces the most challenging phase of his political career so far. The Shiv Sena UBT is gearing up for the high-stakes BMC elections which might be held this year. With Praveen Thackeray, Bureau Report, India Today.
Well, it's practically, technically resurrecting the dead, at least in audio, and politically, it can be explosive. I have with me our own AI expert, Cyrus John, editor Emerging Tech, is with us. We also have Nalini Sharma because it's a grey area where it comes down legally what action can be taken, if at all, where the use or the misuse of AI is concerned. But I want to bring in Cyrus. Cyrus, because AI is developing so quickly, how is this even possible right now?
So, Preeti, if this was happening in 2020,
right,
I would have been surprised. But it's happening in 2025. AI has grown so much. And the kind of tools that are available online, it's not very difficult for anyone to create an audio rendition. So what you have to do, you basically have to have reference audio of anyone. It could be you, it could be me. Reference audio, just put it into an AI software. Tell the AI, okay, this is the audio clip, process this, and then create something that I'm typing. It's that easy. So the thing is, there are free tools now. Free tools that can make something like this happen. And it's just not audio. You can actually make video. So Chinese models right now are creating something just out of one image. Can you imagine?
Wow. Okay.
Just one image, and you can create 20-second videos from that.
So you're actually telling me what we see, because in this particular rally, this was just an audio.
Correct.
You could hear him in audio.
Correct.
But we have the kind of technology where we can create a video as well of Bala Sahib standing there and addressing the crowds.
Absolutely, absolutely. All you would need right now with the kind of AI advancements we have, all you would need is just feeding a couple of images or maybe video. Because see how this can happen. Anyone, a famous personality, politician, has such a massive digital footprint right now. And if an AI engine, if you feed all of this data into that AI engine and just tell, okay, I want this person, this AI render, to just speak this for me. not audio, just video, anything can be made possible. And it's been happening for a long time. I don't know why people are surprised because something like this has happened, because it's, we've seen politician memes also being created like this, and especially in the US, we've seen a lot of these memes come out. So the fact that it's happening in India, it started, I think...
But do we have our own technology, our own tools to do it, or are we borrowing tools?
So right now we are borrowing tools. A lot of the Chinese tools, a lot of the American tools are being deployed for this. But because of the internet, this democratized version of the internet where any tool can be downloaded for free. So people are just using it. It's very easy to download and use something like this.
But, you know, to do something more refined, does it take a lot more money? Or do you think, like, to get a flesh and, like, of course, not flesh and blood, but a video image of...
You won't believe it. I just need to invest 1,000 rupees. Less than 1,000 rupees, and I can have anyone's image, politician, celebrity.
Like a hologram?
They can be in 2D. So right now, we are not at the level of creating hologram. 2D images you can present on a video, and then make them say anything that we want. So right now, the technology is restricted to only video, but again, it's so advanced that you need just a couple of images, because AI works on prediction. If I have the front of the face right now, it can predict what my right and my left would look like without me even turning. So that's how advanced it is. And for voices, you need just a 15-second clip, enter that into the AI tool and say, okay, I want this voice to be replicated, and I can type any sentence I want, and this AI will run it. So it's
my mind's racing because there are elections coming up. So I'm thinking Karunanidhi, I'm thinking Jayalalitha. It's all there. Rajiv Gandhi, Atal Bihari Vajpayee. There's a lot going on there. But Nalini, I want to bring you in there because there's such a grey area where India is concerned. But first, Nalini, I'll bring in Cyrus in this conversation. Cyrus, do we have any laws that govern this at all?
Right now, there are no laws as such. None as such. Because
across the world?
Across the world, we can say China has been very strong in terms of releasing laws against something like this, because their political spectrum, a lot of it is confined. They wouldn't want any kind of propaganda being spread on social media of any kind. So they've put strict laws that anyone seen propagating AI videos, specifically of politicians or anyone, will be prosecuted, will be jailed. So a lot of the countries are trying to adopt something like this. Nothing concrete in India right now, but seeing something like this is happening, I think things need to be put in motion now.
There was already, because I remember during the Lok Sabha elections, Nalini, I'm going to bring you in all this as well. I remember the BJP had launched a complaint that the opposition had tried to doctor the voice of Amit Shah in a rally through AI. And, that's a case that went on. But away from that, Nalini, the legal space where use or the misuse of AI is concerned is very, very grey in India and very, very nascent, something we really need to start developing to get safeguards in place.
Preeti, there are layers of complexities when we talk about the use of AI in this manner. Number one, if we talk about personality rights in general, not just through use of AI, but personality rights in general, there is no law in India that actually protects anybody's personality rights. It's through different other laws like the Trademark Act, the Copyright Act. Under the Indian Constitution, you have the right to privacy. So it is by virtue of other laws that people seek to protect their personality rights. Number two, like Cyrus correctly pointed out, we also don't have any legislation that regulates AI. So that's another layer of complexity. The third layer of complexity in this case is that this voice has been used posthumously. So there is no living person who actually has the right over the use of that particular voice or a person's image or anything that defines
I'm going to come in because I'll tell you what, there's a lot of question being raised here because his voice was being used, of course, in a rally, but used by his son because it's Uddhav Thackeray. So because he was the father, is there a bloodline to it? Maybe if Eknath Shinde uses it, he cannot because you're not related.
Preeti, that's a very interesting question because that's exactly what I was getting to. Although we don't have all these legislations, what we do have are court judgments. So we've seen a slew of personalities from Amitabh Bachchan to Dilair Mehndi to Anil Kapoor to Jackie Shroff, Aradhya Bachchan recently, who've all approached courts seeking to protect their personality rights. Now, the landmark judgment about the point that you are talking about can legal heirs use the voice or image or any likelihood, any distinctive trait of the personality of somebody after they've passed away? Interestingly, is in the case of Sushant Singh Rajput's father. There is a judgment of the Delhi High Court. So there was a movie that was going to be made on Sushant Singh Rajput's life after he'd passed away. His father had approached the court saying that his personality rights are going to be protected by him because he, as Sushant Singh Rajput's legal heir, has inherited his rights after he's passed away. But in that case, the Delhi High Court, I beg your pardon, had categorically ruled that personality rights are not transferable, which means that after a person has passed away, their personality rights cease to exist. They cannot be transferred to any legal heir, which means that not only is Uddhav Thackeray authorized to use this, but anybody else also might be authorized to use this in light of this judgment.
You know, it's very interesting, Nalini, because what if somebody tomorrow puts it in his will that not this child, but this child can use my personality rights? And then, you know, it's a different ballgame altogether. But thank you, Nalini and John. Thank you. I appreciate it for you both taking the time out and, talking to us about AI and how quickly it's developing and with what just happened in that rally in Nashik. Amazing. And you're going to see a lot of that coming in, viewers. Lots of elections coming in where political use of AI is concerned. I still remember the first time it was used, not posthumously, but was in the elections of Gujarat in 2012, where there was a hologram of then the Chief Minister of Gujarat, Narendra Modi, which completely, took everybody by surprise. And there used to be people who used to go more to see the hologram rally than Narendra Modi's rally. So very, very interesting times, how quickly it's developed. In a shocking turn of events, a man was found dead in Meerut, Uttar Pradesh, with a snake discovered right under his body. Initial reports suggest he had died from snake bites, but new developments have now revealed chilling conspiracy. The real killer was none other than his own wife, Ravita. What was believed to be a snake attack was actually a carefully orchestrated plot to murder her own husband, Amit.
A couple of days ago, Amit was found dead in Meerut, Uttar Pradesh, and a snake was recovered from under his body. It was reported that Amit died of snake bites. But now there is a twist in the tale. The local police have now unearthed the real conspiracy. Amit did not die of snake venom, but he was killed by his wife, Ravita. It was she who hatched the poisonous plot. Ravita was allegedly having an extramarital affair and plotted to kill her husband. She strangled Amit and placed a snake under his body, so his death appears to be from a snake bite.
इसका कारण थ्रॉटलिंग है, जो थ्रॉटलिंग स्मूदरिंग, जो गला कह लीजिए कि सांस फूलने से मृत्यु होती है, तो उस विषय में विस्तृत जांच की जा रही है और जो विधिक कार्यवाही है उनके परिजनों से संपर्क करके थाने के द्वारा की जाएगी।
It was the autopsy that revealed the true extent of horror. Amit was rushed to the hospital on suspicion of being poisoned by the snake. The hospital declared him brought dead. Post-mortem was then ordered, which revealed that Amit died of strangulation, not snake bite. Both the accused, Amit's wife Ravita and her friend Amardeep, have now been arrested.
कोई आइडिया कैसे आया?
आइडिया ये मेरे नेता रविता ने पता क्या क्या कहा रविता ने तुम?
क्या क्या कहा?
पूरी पाए मुझे मार पीट रहा है, आप ही बहुत वो कर रहा है।
ये सांप का आइडिया जो है क्या नाम रविता का था, तुम्हारा था?
This is the second sensational murder that has stunned Meerut. First, it was Muskan, who chopped up her husband's body and stuffed it in a blue drum. Now, Ravita and a snake bite conspiracy. Bureau Report, India Today.
All right, time now for our fact check segment. A viral video has been doing the rounds of Karni Sena workers' fierce protest in Agra, furious over a parliament statement by Samajwadi Party MP Ramji Lal Suman. Take a look at what India Today's fact check team found out.
You are watching Fact Check segment where we bust fake news. On 12th April, Karni Sena workers held fierce protests in Agra, furious over a parliament statement by Samajwadi Party MP Ramji Lal Suman, who allegedly called Rana Sangha a traitor. The remark has sparked widespread outrage across the Rajput community, with demonstrations, even vandalism reported outside the MP's home. A video is circulating online showing a dramatic nighttime bike rally, with a long convoy moving through streets under police watch. This video has nothing to do with Rana Sangha or the protests. India Today's fact-check team traced the clip back to an unrelated event, a traditional horse cart race held in February 2025 between Karnataka's Chinchli village and Maharashtra's Sangli district. This fact-check on viral fake news is done by India Today's team AFA. This is AI Sana signing off.
All right, with that, it's a wrap on this edition of News Today. Have a good night.